want to hesitate at any point. If there's a topic that you think you need some follow-up on or have some questions about, I'm more than happy to have that discussion, because it's a topic that's kind of near and dear to my heart. I think that, and one that is gaining constant momentum in the legal system. Trying to devise and provide opportunities for alternate dispute resolution, ADR. And it's a buzzword that you hear throughout the legal system. That's not intended to be a criticism of our system as it presently exists, the traditional notion that you would bring a lawsuit and that a judge or jury would ultimately decide the merits of that lawsuit. It's a great system, and it's served us well. But it can be time-consuming, and it can be expensive. And there are alternate means available, and some steps that you can take as entrepreneurs, business owners, or those that might be facing the prospect of having tried to resolve some of these disputes. You can anticipate them in advance and plan for them. No one plans for litigation, or no one hopes to be in litigation, but it's a reality. There are going to be disputes, and as those disputes develop, what's an effective and efficient means to resolve them. You will hear some terms that I will use today as I go through the various options and alternatives. One of them is binding and non-binding. Many of these ADR mechanisms can put the parties in a position that by employing that mechanism, you are in fact going to be bound by the decision. Others are non-binding. The parties participate in a good faith manner to try to resolve a dispute. If they are unable to do so, the results of that dispute are essentially washed away or eliminated, and you go on to perhaps the more traditional methods of resolving a dispute. You will also hear me use the word neutral. Mediators or individuals that become involved in helping the parties try to resolve a dispute are often referred to as a neutral. And there are many means and methods by which you can determine who would be an appropriate neutral. There are services that provide neutrals. We'll also talk about the fact that many of our courts, in some instances, have mandatory mediation where the neutrals are provided through the court, and in other instances where there are private lawyers who make themselves available and are trained neutrals. So you'll hear that expression as well. First and foremost, I think that alternate dispute resolution for entrepreneurs and business people is especially effective because in your businesses you are problem solvers. You face it day in and day out, situations which require you to weigh out what the cost benefit of a particular situation is, what's best for the business, what's the most efficient use of my time, and it also allows you to be creative. The traditional court setting, while an effective means to resolve litigation or resolve disputes, is often very limited in terms of the options that might be available to the parties in a traditional lawsuit. A judge or a jury is going to be bound by the rules of law, specific pattern jury instructions that the court has to give, and limited relief that might be allowed by the statute involved or by the rules that are in play. These alternate dispute resolutions in many situations allow your creativity as business people and problem solvers to create or fashion a result that can be a winning combination for both sides or all parties in the dispute, and allow you to make decisions for your business that ultimately a judge or a jury may not be able to enact because it's simply not within their rules. The other aspect of ADR that I think is important from a business standpoint is that it puts you in control of the process. I often, when I begin a mediation, describe the legal process where a judge will become involved in your case and he or she may make decisions along the way. If it ultimately goes to a jury, we pick 6 or 8 people over the age of 18 that are U.S. citizens that live within the jurisdiction, and we invite them into your boardroom to make a decision about your company. Again, an effective means of resolution, but may not be the most effective for your business. And of course, if you don't like what a judge or a jury does, there are 5 judges that sit down the street on East Avenue that will come into your boardroom and help you make a decision, or 3 sitting down in New York City if it's a federal court situation that do the same. So ADR allows you to plan for potential disputes. It allows you to be actively involved in controlling to some degree how those get resolved, and puts you in a position of dictating how it proceeds, as opposed to being caught in a court system and having control relinquished to some degree. So the first ADR mechanism that we're going to talk about is, it's kind of a general range. Is that concept of non-binding without third-party intervention, and that's where the parties themselves have taken on the dispute and are attempting to resolve it without the help of any third parties. There's non-binding with the third-party intervention, and we'll talk about some of those means. And then the final is binding with third-party intervention, where someone comes in, or a group of individuals are employed by the parties to make a decision that will be ultimately binding on the parties. When should you be thinking about ADR? Shouldn't be thinking about ADR when you get served with a summons of complaint, or you determine that you have to call your lawyer and bring a lawsuit. Often ADR should be considered, and I recommend it very highly, that at the beginning of any relationship. If you're negotiating a contract, for instance, and you get through all those critical terms: price, timing, the deliverable, who's going to do what. There are all those, what a lot of times people say, there's all those standard clauses at the end of the contract. You know, what's the forum that it's going to be in, or what law is going to apply, or if one part of the contract is disallowed, the rest of it will be held in place. That's an opportunity to consider, if something were to go awry with that contract, or with the relationship, or with the relationship between employer and employee, what means would we use, or can we use, to resolve that dispute? And plan for it in advance. Many default agreements will say, well, if we have a problem, we're going to go to AAA arbitration. You ought to be asking your lawyer, what does that mean? What's going to happen when I go to AAA arbitration? What do I have to do? What are going to be my rights? What's going to be the cost? And as we'll talk about later, one of the components of arbitration, that while it is an effective means to a result, one of the costs of that is that the ability to appeal from an arbitration decision is very, very limited. So you're really putting a great deal of faith in the arbitrator or arbitrators that they are going to adhere to the law as you understand it and decide the dispute within the bounds of the applicable law and the contracts and the dispute at hand. In New York State, absent some type of gross conflict of interest or glitch in the process, it's very difficult to convince a court to undo an arbitrator's decision. As long as you know that going into it, then that's at least you can understand that. But often when we throw in that clause that says we're going to use AAA arbitration, and you go through the whole process and they say, wow, the arbitrator really blew it, he missed this, this, and this, you may not have a mechanism or a means to be able to appeal that. And that's something that you should consider. So any effort that you make when you think about that, when you're negotiating an agreement or a contract, to look at it and say, are one of these mechanisms, these ADR mechanisms, available that might shortcut or make a dispute resolution more efficient for my particular business or my particular anticipated problem. So thinking about ADR in the front end is a very useful and helpful endeavor. The first and basic ADR is something that you've probably practiced from the time that you began your business efforts, and that's simply negotiation. If you anticipate or you discover that there's a dispute or a problem, direct negotiation with the parties involved can often be, and probably often is employed without having to invoke the involvement of lawyers and some other mechanism, bringing in third parties to help you resolve it. One of the things that's important from a public policy standpoint that really is an overlap to all of these ADR mechanisms is what I call evidentiary protection. Under the New York, what we call the Civil Practice Law and Rules, it's referred to as the CPLR, or under the federal rules of evidence, the settlement negotiations, discussions about settlement, are protected from being disclosed or being discovered or to some degree being used against you should the case not resolve and proceed to litigation. And the public policy behind that is that when deciding what's admissible and not admissible, the rules of evidence encourage candid and good faith negotiations, which might involve the discussion of both the strengths and weaknesses of your case, without it coming back and being used as a weapon against you later on in the litigation, if it goes that way. And I do a number of mediations, and I encourage the parties when they are talking and caucusing privately, that to be candid and to be realistic about their case and what the issues are, because it is protected with that evidentiary shield. And if you involve a third-party neutral, he or she is protected from being brought in to testify as to what the negotiations were prior to the dispute being brought to court. Yes, please.
How do you know what's protected and what isn't? Is all this in writing relative to
Well,
these negotiations?
there are rules of evidence. 408, for instance, under the federal rules of evidence, says that you can't introduce into a proceeding evidence of negotiation, settlement efforts, admissions that may be made under those circumstances. You will often see parties exchanging information, especially when the lawyers get involved, a legend at the top, for settlement purposes only and without prejudice. And that label is an indication that this is a statement that we're making for the purposes of trying to resolve a dispute, and it's not intended to bind us or come back later on and be used as a weapon against
So
us.
that tells you when the switch has been turned on.
It typically in the formal lawyer proceedings, but when often if you're in with a mediator, the mediators will have an agreement that says all of these discussions are confidential and that they are protected either by Rule 408 or under the CPLR, which has a similar provision.
Good, thank you.
So that is, and in those negotiation is obviously something that can be employed at any point along the timeline of a dispute. But as the dispute goes farther and farther along, when lawyers become involved, there are some ethical considerations that I cannot communicate as a lawyer with a party that's represented by another lawyer without that lawyer's permission or that lawyer's presence and involvement. And the same holds true with the decision makers and the like, that if you're going to call up your former vendor or your supplier who you have a dispute with, and you know that he or she is represented by counsel, it's often the best practices to make sure the two attorneys know that the decision makers are going to talk. And that's often a fruitful and useful exercise because you know how your business works, what the consequences are, and sometimes those personal relationships go a long way at resolving a dispute early on or as the litigation and dispute progresses. Another means or mechanism is mediation. And I'm going to spend a fair amount of time on mediation only because it has become more and more of a mechanism that the courts have literally imposed. At least two courts in our immediate jurisdiction, the Western District of New York, which is the Marble Building to our west, I guess, or to our south, the Northern District of New York, federal court. So if you're in federal court anywhere in upstate New York, within 60 days after that litigation is commenced, the court will literally order mediation. And the parties, with the rare exception, are required to spend 2 hours with a trained mediator in an effort to have early intervention in the case to see if the case can be resolved. And statistically, it is proven that there's a high rate of success when the parties join together early on with the assistance of a trained mediator and work through some of the issues in the case. And it doesn't have to be all of the issues in the matter. Sometimes the mediator can be asked to help with specific portions of it or to help the parties resolve some issues and allow the others to be ultimately litigated. The advantages of mediation. Did you have a question?
Yeah, does a mediator need to be an attorney? You said a trained mediator, but does it have to be attorney? And is there a certification or something like that that goes with it to know that it's a trained mediator?
Good question. In the federal court system, there is a panel of attorneys who have been designated by the court, have gone through a required training program, which involves about 3 days of full-day mediation training, and that panel is available to the attorneys to select for the court-ordered or court-sponsored mediation. The attorneys have agreed to do that, those mediation services at a reduced rate, normally a private mediator may charge for his or her preparation time. The court rules don't permit that.
So those are all attorneys?
Those are all attorneys.
Yeah.
There are also private mediators who may or may not be attorneys, depending on the area of interest or expertise. For instance, in securities arbitration and mediation, they are often pick one person from the industry, one person from the general business community, or actually two people from the general business community. There are mediators who assist in domestic relations matters through the Center for Dispute Resolution, who may be trained mediators, having had a training and instruction in mediation, but may have a social work background, may have other disciplines that they're involved in. So, and we'll talk a little bit more about there's some times when the mediator you select may be someone with specific training in an area. For an engineering matter, for instance, or an accounting matter, you may want to have the neutral to be someone who is intimately familiar with very detailed and specific disciplines that bring a level of expertise to the situation. From the panel of lawyers that are available, parties will often look for lawyers that might be involved or active in the area where the dispute is, the area of law that the dispute is. For instance, if it's a labor and employment matter, you may look at the panel and find a lawyer that you know has been involved in labor and employment matters in the past, and he or she would then be familiar with the dispute that you want. In state court, the mediation is not necessarily mandatory, but there is a lawyer employed by the state of New York. His name is A.J. Burke, and he is available to the parties in state court matters in the appropriate cases. The court will either order the parties or more likely and more often encourage the parties to seek out the help of that mediator. It's free, and he has been trained and has a great deal of experience in litigation. Yes.
So once a mediation happens and they've come to an agreement, does that have to go back before the judge if it's been demanded by the court that they go to mediation?
And I'll say it depends. In federal court, for instance, the mediator will report to the court that the parties have negotiated a resolution and that they will be putting together the appropriate releases and settlement agreements that they think reflect the terms of the agreement. And ultimately, what might be filed with the court is just a single sheet of paper that says the case is dismissed. And same with state court. It's called a stipulation of discontinuance. That is, in one respect, a real advantage of mediation, is the confidentiality of it. Like inviting jurors and the like into your boardroom to make a decision for you, we are in New York, courts of public record. Anything that happens in the courtroom, short of an order, sealing records, is as a matter that people can review and look at. If you reach an agreement in a case, it's not uncommon that the parties say in advance, this agreement will be confidential. And if someone asks you outside of your accountant, the government, or your family members, the matter was resolved to the mutual satisfaction of the parties. So mediation allows you to, one of the big advantages of it is, in addition to control, confidentiality of your and those rules of evidence also apply to those mediation forums, so that the information that you exchange. So settlement agreements are typically what comes out of that. The exception to that, there are a few, bless you, there are a few situations where the court has to give approval. For instance, if it was an infant settlement in a case involving someone that's either disabled or an infant, the court would step in and make sure that's approved. If it was a municipality that you were involved in, municipalities can't insist on confidentiality because it's often taxpayer dollars that are involved. They are keepers of the public fisc, and those often have to go, for instance, to approval to a school board or to the city council, and that's a matter of public record. Yes, please.
Just as an overview, we may be covering this later. Are there
Yeah.
any particular industries where this is more prevalent or better used? Labor disputes versus intellectual property versus contracts?
I think that you will find in labor disputes, depending on the nature of the relationship, collective bargaining agreements may very well have provisions in it that involve arbitration or multi-level type of ADR. First of all, non-binding discussion. Secondly, a decision before a panel or a peer review. And then finally, ultimately, if no one's happy with that and it's not binding, on to court. So collective bargaining agreements would be an example. Employment agreements. I've seen employment agreements where before anybody brings a lawsuit, the parties are required to at least engage in a good faith effort in mediation. Or the parties are given a certain period of time to try to resolve the dispute informally, and if not, you limit the forum to AAA arbitration. And that way you have at least taken control of how a dispute would be ultimately resolved. In some professions, the medical profession, for instance, counting profession, if they have disputes, they may very well, we'll talk about it a little bit later, but have a peer review type of resolution, a dispute resolution, where a group of 3 accountants will hear both sides and then from their expertise decide whether or not the work that was done or the method or how to resolve that dispute. And their expertise is obviously of value for that. One of the key components, I think, of any mediation is preparation. Many mediators have different ways that they ask the parties to present the information to them. The most common is a mediation statement that's prepared by the parties or their attorney or in combination. And very careful thought should be given to that. And because you really want to convey to the mediator what you think is the most important components of the dispute, where you think that the strengths of your case lie, and what are the practical and business reasons why you're taking the position that you are. I don't find it, maybe Justin could comment on this because he's done a lot of mediations, but I don't find it particularly effective for your mediation statement to be a restatement of your brief that you've submitted to the court and on your argument. Because the mediator is not going to resolve your legal issue. The mediator is going to facilitate conversation back and forth between the parties to try to resolve a case. But it's your decision and your control. There's no such thing, in my mind, as binding mediation. You mediate in good faith, you discuss a resolution. If you reach it, then the parties document it and they go forward. When I mediate a case in federal court or privately, if we're not able to resolve it, I file a one sheet of paper with the court that says the parties met, they mediated, we were unable to resolve it. Judge doesn't call me up and say who was good, who was bad, who was right, who was wrong. It's intended to allow you to have the control over that process, and different mediators have different styles. I ask for the mediation statements to be submitted to me in advance and in confidence, not exchanged with the other side. I think it allows everyone to be more candid and know that I'm not going to reveal that information until you give me permission in the mediation to do it. But I think providing any type of background, photographs, videos, information that you think would be meaningful for the mediator, and then also sharing with the mediator some of those intangibles that are behind, that you may not want the other side to ever know. I mean, you've got a suitor for your business and at the door, and the suitor has said, you get rid of this lawsuit and we can move forward on our deal. That gives you a whole different motivation, and sometimes sharing that with the mediator and allowing him or her to use their skills to try to get the other side to a deal that can work is great. And you talked about intellectual property. I find those are really interesting mediations in the sense that there's often a business relationship of some sort, and the parties can come away having come into the mediation at loggerheads, both insisting that they each owe each other hundreds of thousands or millions of dollars, and they walk away with a royalty agreement and a sharing arrangement where they say, you know what, instead of fighting, why don't we both go on and make money, and we'll resolve this in a business fashion. That's not something a court can necessarily do, but it does play into the hands of creative business people that know how to deal with that. Some mediators take an evaluative. I rarely give my opinion of what I think the value of a case is or how it should be resolved. I act more as a facilitator. There are some mediators that are more evaluative. They'll say, well, gee, in my experience, this case is worth X, Y, and Z, and you ought to aim for that. We talked earlier about where, in addition to the court-certified mediators, there are organizations. There's the American Association of Distinguished Neutrals. These are individuals and or lawyers, sometimes retired judges, who have gone through a certification process, whose main focus of their practice or their employment is mediation, and they are available through various services and even on a private basis. There are a number of attorneys in town that a large part of their practice is getting involved in mediation. Matrimonial cases, domestic relations cases, have a number of mediators that are involved. There's also what they call a collaborative law effort to try to mediate matrimonial disputes. Those are a group of lawyers that work together, identify the common issues in a matrimonial matter, and try to work with the parties in advance of any legal proceedings to reach agreement on those common issues. The mediation, and I'll stay on it just for a minute, just so you kind of have an appreciation of the process. After those mediation statements are presented, and the parties have met, or at least your side of the group has met, and it might involve your accountant, it might involve an insurance adjuster, it may involve key members of your team and your business. There should be a discussion in advance. What's our goal? What are we trying to accomplish in this mediation? And who attends the mediation is also a very, very important sign. I've often, I don't start with the parties all in the same room. I don't find that very effective because you often just get opening statements from the lawyers. But I do find that one of the first questions many of the parties will ask me, who's in the other room? Who did they send? And that's a signal as to the importance or the significance that it's been given by one side or another. I think, and most mediators insist, that the decision maker be in the room, and with the rare exception, be involved in the mediation. Sometimes because of distance or travel or the like, they'll say, well, the decision maker is right there available to you any minute. But so much happens in the course of a mediation, the back and forth, the flow, having the decision maker there sends a real signal and also puts you in the driver's seat so you can assess what's going on and make decisions that way. Same holds true if you do have insurance coverage and they're handling the mediation for you, to the extent that you can insist and ask your insurance company, make sure the appropriate person is there who has the authority to protect my interests and potentially resolve a dispute if that makes sense. Yes, please.
So you just mentioned there are a lot of times, even if they're going to mediation, both parties will still have a lawyer representing them?
Yes.
Okay.
Yeah, if it's court-ordered mediation, it means a lawsuit's already been commenced.
Okay.
And an issue, what they call issue's been joined, there's been a summons and complaint, an answer given, there may be limited discovery. I've had situations, for instance, it's very common in personal injury matters, where you know of an accident, or you know of a circumstance where your insurance kicks in. No one has started any litigation yet. The parties will say, why don't we get a mediator involved privately, and let's see what the mediator, and when we get everybody in the same room, if we can resolve it before we get to litigation. You could have an agreement that says, when a dispute arises, we'll agree within 30 days to get a mediator, and then within 60 days meet with that mediator before anybody starts any lawsuit. But you would typically, under those circumstances, likely have your lawyer involved. Some of you may have had experience with employment issues that get over to either to the Department of Labor or to the Division of Human Rights or the EEOC. They have mediation programs, and certain cases get slotted into their process, and they will invite you to come and participate in a mediation. You may or may not have a lawyer in those circumstances, depending on the status of the severity of the employment issue and the status of it. But they often encourage that as well. The mediation sessions can last 2 hours, as the federal rules require. It can last 2 weeks. It's not uncommon that the parties leave with the mediation with some things to think about, or some information to to obtain, or to get permission from some third party that they'll need to accomplish what they had hoped to. Or a persistent mediator calling a week later and saying, all right, you know, the dust is settled. Have you thought about this a little bit more? Have you given it, you know, have you run it up the flagpole and considered all your options? One of the things that I always emphasize in when we meet and a case has been started, litigation is inherently uncertain. There's just twists and turns that can happen in the course of a lawsuit. And no matter how good you think your claim is, our malpractice carriers will not allow us to guarantee you a result. And so getting a resolution of a case, not necessarily a sign of weakness, but rather recognizing that litigation is expensive. You have you relinquish some of your control. You relinquish some of your confidentiality about your business, and it brings a certainty to it, and a closure that often is really important, because you're not in the business of litigation. You're not in the business of dispute resolution. You're in the business of making products or providing services, and that's where you want to spend your time and your energy and your money. Mediations, as I say, can result in a settlement agreement that is binding on the parties, and if that gets breached, one of the things you want to think about in your settlement agreement is what happens if this settlement agreement we reach goes south. And you may build into that. We go back to the mediator, or we go back to the judge under which that agreement was reached. But you do want to think about that piece of it. Or you may find that in the course of negotiating your settlement agreements, there are issues that come up. You agree, or at least employ the mediator back to try to work through some of those wrinkles and get you to the ultimate result, which is the settlement that you reach. If a party breaches a settlement agreement, you would have the remedies as you would under any circumstances of breach of a contract, and the right to enforce those rights. Another mechanism is I have it as mini trial here. You'll hear the expression in New York State as a summary jury trial or a summary trial. It's been employed. We have in the New York State system what they call the commercial division, and that is a judge or judges, depending on how big the jurisdiction is, who are specifically assigned cases of a corporate or commercial nature. And the thought behind that was that judge or those judges would become very familiar with the disputes that face businesses, have early intervention in the cases, and manage them in such a way that would be conducive to getting them resolved. I often question Judge Kay when she said, well, if we have a commercial court, you know, people will be more inclined to do business in New York. I don't know if that's necessarily true, but it has turned out to be an effective means of, or an effective court, and the judges that we've had locally are become very familiar with business issues and work through them. But one of the options is what they call a summary jury trial or summary trial, where a group of potential jurors are brought in. The case lasts one day. Each party gives essentially a snapshot of their case to a group of 6 or 8 people that would be potential jurors in the case, and they deliberate after instructions from a court on a very limited and directed basis, and provide what they believe to be their verdict. It's not binding. I mean, you can, on an agreement, do that, but it's, under the system, it's non-binding. It is intended to allow the parties to assess if I'm going to go through a full trial, is my result going to be all that different? And maybe this gives, and sometimes just allowing the parties to have their opportunity to tell their side of it or their story, how the person presents as a witness. You may be the most effective business person in the world. You get on that witness stand, and it's a lonely place, and sometimes it can convince people that maybe we're better getting this resolved along the terms that the jury suggested, as opposed to continuing on.
Yeah.
So it's a tool, and you'll often hear the judges say, well, we can offer that, and we can make it happen. Another is a term, and I referred to this before, conciliation. It's similar to mediation. It's more often not with lawyers, but with folks that are trained in the area of domestic relations, or sometimes in labor and employment matters, where a dispute has arisen, sitting down with someone and kind of walking through it. Is there something in the employer's personal circumstances, health or family matters, that have distracted them, prevented them from doing their job as effectively? And maybe we can work toward that, a resolution of that issue before issues of employee discipline or termination come about. Same with matrimonial and family matters. Often meeting with someone, talking through the issues to see if there can be a resolution, can be an effective means. It's typically non-binding, and it's an option that often is, in those settings, reviewed. Peer review panels. You find this often in professional settings, the medical profession, for instance, accounting, engineering to some degree. If they believe, for instance, that a physician or an accountant has done something that violates the either their employment arrangements or the rules of their practice, or an accountant has done something that doesn't conform with GAAP, or then you may have a group of accountants that will hear the case and make a decision. So it's almost like a specialized panel.
So it's not between a client, like a patient and a doctor, or a client and a CPA. It's more within their practice?
More within their practice, but it can be in those circumstances as well. But more often within an industry, in a setting to say, we believe that you may have stepped out of bounds, or it's a disciplinary type of proceeding, that we're going to have a panel, a neutral panel of physicians, or a neutral panel of accountants or teachers, educators, that are going to listen to both sides and decide whether or not what happened here stepped out of the rules and the boundaries of our particular discipline. And again, it can be multi-stepped, and it can be binding or non-binding. Sometimes that might depend on the organization, depend upon the rules, depend upon how much negotiation goes on in advance.
So there's no court involved in it, no judge involved in it, this is something that the internal practice, you know.
An internal dispute resolution matter.
Right.
And the only time the court may get involved is, number one, you may have started it, and it says, well, if you start a lawsuit, one side or the other gets to elect that you go to peer review. Or if it's a multi-step process, you may say, if we get all through it, our court can review this on very limited basis. But you tend to be trying to get away from that.
Yeah, right.
And having your own almost specialized court in deciding those disputes. This is a kind of an offshoot or an alternative to peer review and that summary jury trial that we talked about. Business valuation is the issue. Buying out a shareholder or it's often the case a family member, but you've done the work. You've done the work in advance. You've got a cross-purchase agreement that says if somebody leaves the employment or ages out or whatever it might be that he or she is bought out, and there's a formula there, but people disagree as to how that formula applies, whether or not there are discounts that should be employed, and that type of dispute, you may have early intervention in the matter by a trained neutral who kind of does the job of a jury in a summary jury trial. Here's the parties on a very limited basis submit their issues and ask for that neutral evaluator who usually has some experience or expertise in an area to give his or her opinion. Might listen to the two accountants, sit with them and say, one accountant says, well, I think a minority discount should apply or a lack of marketability discount should apply. And the other accountant says, no, not in this situation for A, B, and C reason. This trained neutral listens to all of that and says, well, if I was going to decide that, here's what I think is, and you at least get the benefit of a third party who's hearing an area that might have involved some expertise offer an opinion. And often the parties can agree to somebody that in their industry who would know the practices and the state of the law, as well as kind of the culture of the community, and often can be an effective tool. If you end up in a lawsuit, and you will find from time to time that the judge may become involved in settlement. And some judges are more involved in that than others, just because of their style or their caseload. There's an ethical constraint for the judges in that many judges are a little reluctant to become intimately involved in settlement negotiations because you want the parties to be candid and open with you as to strengths and weaknesses. If the judge is the ultimate decider of law and fact, there may be some aspects of that ethically that they would choose not to be intimately involved in settlement negotiations, but refer it to another judge who would help in that situation. Or if it's a jury trial, some of the judges are a little less reluctant to get involved because the jury is going to make a lot of the decisions, not the judge, in that case. But it's frequent that there will be a conference with the court, and almost uniformly the issue of settlement. And the judge may just simply ask the question, have you talked at all about settlement? Have you considered the resolution of it? And if so, how can I help you toward that? Do we need to do a summary jury trial? Do I need to appoint a court mediator? Do I need to get involved and perhaps try to assist? The same approach that you would take with a mediation, I encourage that you would take with a judicial settlement conference. Prepare. I had a situation 2 weeks ago where we were very early involved in a case that was being joined with another case in Cleveland. We got a call on Tuesday night, and the judge's law clerk said, the judge wants you and your clients here on Thursday morning at 8 o'clock. And the judge said that he wanted us there, so we were there. And quite frankly, the judge had a feel for the case, and it turned out to be a very meaningful and useful exercise. But it's just like those mediation conferences, or just like anything else. You want to prepare for it. You want to be on the same page with your lawyer or your representative in that setting. So when you go into that, you have a clear direction as to what you would like to see come out of the case.
So you knew in that case, you and your client had to go, to Cleveland, and there was probably a client and an attorney on the other side.
Yeah, there were 3 other attorneys and 3 other clients.
Okay, and then, but the judge was essentially arbitrating the
Well, what the judge did was he had everybody.
There was no jury or anything.
Oh no, it was strictly a settlement conference.
Yeah.
And the purpose of it was the judge put everybody in separate rooms and went from room to room and discussed what he saw was strengths and weaknesses and early on. And he said, I'm just trying to see if there's any before we, because this particular judge has what they call a rocket docket, and he prides himself on moving cases very, very quickly. So even though we weren't able to resolve it all there, we made great progress. But we walked away with a July 29, 2019 trial date. So in the next 7 months, there's an enormous amount of work that has to be done, and he made no bones about it. This is the schedule. You will adhere to it,
Yeah.
and so it's a tool that he uses, and he works hard. But that was his approach, and
So there was no settlement that came out of that?
there was no settlement that came out of
There
it,
was a
but
settlement conference, but no settlement, and.
he kind of set the stage,
A
and
path to a trial.
he sent people off to say, before you spend the next 3 months lining up doctors and accountants or economists to do forecasts, and your parties have to come back to Ohio for depositions. Think about what you want to do about this case.
Okay.
And those settlement conferences can come all along the timeline of the lawsuit.
Well, you could have come out of that with an agreement.
We could have come out of it, and any one of the 4 of us or 5 of us could have.
Binding?
It would have been binding, and it still might be. Those discussions, without the assistance of the court, but those discussions are going on based upon the judge's view of how things should shake out.
Okay.
So that's often very. In many respects, a judge will give a little signal in the course of those settlement conferences. I haven't read everything yet, or I haven't decided all of this. That's a tough position that you're taking,
Yeah.
or you might want to think about this and read my decision in such and such a case where that issue came up.
Mm-hmm.
So you get some intel and some feeling about how the judge sees things going.
I have a question.
Yes, please.
In regards to that, it was based off of his feedback that they decided that they wanted to go to trial, is that correct?
Well, it was based on the fact that it was fairly early in the case, and the fact that he didn't settle it that day meant that he was going to send us off. We don't see him again until June 23rd. But we have deadlines of things that need to be accomplished to have that case ready to try by July 29th.
Okay.
So that was his response. I encourage you to try to resolve it. Here's what my thinking is. If you can't, here's what you got to do, and be ready. And that is, that timing, bless you, that timing is a rocket docket. I mean, and he's as I said, very committed to it, and very devoted to making sure that the cases move along quickly. So that's an opportunity, and one that is an alternative to an actual trial. Expert determination is a little bit like the neutral in making a decision, or at least a summary, having a neutral and doing some type of summary proceeding. The parties can agree that we're going to take a professor of engineering at RIT, and he or she is going to sit as our expert. They're going to listen to both sides and make a decision, and we're going to be bound by it. It's kind of a form of arbitration in a way, but you're picking your decision maker based on his or her experience or familiarity with a particular topic, and explaining IP to people sometimes, or the intricacies of a particular business might be a challenge. And having someone with the requisite expertise to decide, especially if it's someone that both sides hold in high regard, then you've gotten the dispute resolved without a lot of, you can move on and get it behind you. Arbitration. This is probably, with mediation, the biggest area of, the most common alternate dispute resolution to our traditional legal system. And the biggest, I think the biggest component of arbitration, or the most significant component, is the fact that with the rare exception, it's binding. The parties have agreed to a method of resolving a dispute where an individual or a panel of individuals is going to make a decision. And that decision, with the rare exception of some type of conflict of interest or fraud in the process, is going to be binding on the parties and result in a piece of paper that one side or the other can take to the court and enforce. It's, again, it's something to think about when you're drafting or when you're getting into an agreement, and you see those provisions at the end, and it says, well, if we have a dispute, we're going to go to AAA arbitration. Often contained in agreements. AAA is an organization that has arbitrators that have signed up with them and have been trained. They could be lawyers, they could be accountants, they could be business people. You'll submit the claim to arbitration and pay a fee. The arbitration, AAA, will set up a schedule, appoint the arbitration panel. Sometimes they'll give you 5 names each side. Here's 5 names of people that we're going to consider as arbitrators. Let us know if you have any conflicts with any of those folks, or for any reason you don't want those people to be considered. And you get your panel, or you get your arbitrator. He or she then works with you and says, all right, under the rules of arbitration, you get so much discovery. And discovery is just the exchange of information in advance. What documents do you need from them? What documents do they want from you? Sometimes the parties can agree to depositions. A deposition is just the opportunity to take a statement from the other side under oath in advance of the litigation. Sometimes the rules don't permit that. So you may be in an arbitration system that has very limited discovery, very different than what you would have in a normal court setting. You need to understand that's got its pluses and its minuses. It's less intrusive, it's less costly, but in terms of full preparation of your case, you may say, well, gee, I really would like to have the opportunity to examine that witness before he or she shows up at the deposition, at the arbitration, and there's no mechanism, or there's nothing under the rules that allows you to do that. So you go into the arbitration, and what he or she says is you're going to have to deal with literally on the fly. People often, one of the arbitration is touted as being a quicker resolution. Statistically, I don't know if that's proven out to be true, but the lack of an ability to appeal certainly brings finality once the arbitrator or the panel has made their decision. Some industries rely on it. If any of you have a brokerage agreement or work with any type of stockbroker, you will see in very, very broad, bold letters at the bottom that you have agreed that should you have a dispute with your stockbroker or your financial advisor, that you will be going to an arbitration program sponsored by FINRA. And there are rules that govern that, and the Supreme Court has said will allow you to deny someone their right to a jury trial. They have to know about it, they have to understand it, and you have to run an arbitration program that is fair and allows for a meaningful resolution. It can't be a inside baseball and a whitewash of the claim. But that's a typical scenario. You'll see it sometimes in financial documents, in your engagement letters or your retainer agreements with a law firm. They will indicate that there is a fee arbitration program offered by the Bar Association, and you have an option that if you dispute a fee, that you can engage in an arbitration program in an effort to try to resolve the fee dispute. The arbitration tends to be a much more formal process. It's not uncommon in labor contracts, collective bargaining agreements. We'll have an internal arbitration program for employee discipline or for grievances that employees may have against the employer, and likewise issues that the employer may have against the collective bargaining unit or some practice that's going on. And you have a lot of control over that, and you can structure an arbitration proceeding or process that you think is helpful and meaningful to your business. But I think one of the most what you have to understand up front when you see that notion that we're gonna arbitrate this dispute, that you often can be limited in the scope and the amount of discovery or information that you can get in advance, and that limited appeal option. You know, a lot of folks say, well, arbitration is, it's arbitrary. The arbitrator doesn't, the arbitrator doesn't have to necessarily, religiously adhere to the rules of law. He or she can get a feeling for who's been had and issue a decision that way. And you may not agree that it meets every rule that's contained in the statute or the like, but your ability to upset that or reverse it is very, very, very limited. So you just need to know that rule in advance. Question?
So I am a commercial realtor, so we are required to do arbitration with any of our disputes in our contracts. Although quite frequently in my industry, people talk about lawsuits and lawyers and all that kind of stuff. So I'm just curious sort of what your take on that is. I'm sure maybe you've come across some sort of real estate issues where maybe it was supposed to go to arbitration, but maybe it didn't, because, for various reasons. So I was just sort of wondering what your experience was with that.
Well, if you believe that you have a binding agreement that requires a dispute to be arbitrated, you can actually, and someone brings a lawsuit tomorrow, you can actually go to the court and say, I want this, we have an agreement that says we're supposed to arbitrate. I want this lawsuit stayed until we do the arbitration. Or I want you to decide, Judge, whether this contract requires them to go to arbitration. So that, if you feel like they're not honoring the agreement that you made, that this dispute was going to be in arbitration, then you can enforce that right. You may waive it. It may not be you're obligated to do it. And it may be because there are some concern about the arbitration forum not being the best way to resolve your dispute, that you'd rather be in court. The other thing is that sometimes you might need the assistance of the court. For instance, if it was a piece of real property and the dispute was a title dispute, you may have to start an action to get what they call a lis pendens, which is a notice to all the world that there's a dispute over the title to this property and nobody should convey it in advance or convey it until the dispute is resolved. Or if you need what's called a preliminary injunction, which is essentially a court saying time out. Before you do something, we need to solve this lawsuit, because if I don't say time out and one party proceeds the way they are, the omelet's made, the eggs are cracked, and you have no way of putting it back together again. So even in the presence of having arbitration agreements, you might need assistance from the court for some preliminary or temporary relief while the arbitration process is going forward. So that's a scenario that you might find yourself doing some litigation as an assist or as a part of an arbitration. Any question? I don't know how we're doing on time. So.
We're a little heavy, but
Okay.
Yeah, we're gonna wrap this
Okay,
up, just to be mindful of everybody's.
I appreciate everybody's.
We wanna end on time. Thank you so much for coming. If you have questions for Bill